Let's say there's a US citizen husband in the United States and he marries an immigrant spouse. His immigrant spouse has 2 children, and those children are outside of the US in the immigrant spouse's home country. Those 2 children are under age 18. So in this case, those 2 children now have a US citizen parent. A US citizen step-parent by operation of marriage, by operation of law, but for immigration purposes, that's the same thing as a US citizen parent. In this video, I want to talk about creating a valid step-parent or step-child relationship for immigration purposes so that you can file a family petition for your non-biological stepchild, or a stepchild who's a US citizen can later, when they reach age 21, file a family petition for a parent who needs to fix their immigration status. So let's start by talking about an example. Let's say there's a US citizen husband in the United States and he marries an immigrant spouse. His immigrant spouse has 2 children, and those children are outside of the US in the immigrant spouse's home country. Those 2 children are under age 18. So in this case, those 2 children now have a US citizen parent. A US citizen step-parent by operation of marriage, by operation of law, but for immigration purposes, that's the same thing as a US citizen parent. So as long as the US citizen parent married the immigrant parent before the children reached age 18, and those parents are in a good faith marriage, and can prove that it's a good faith marriage, those children now have a US citizen parent who could file an immediate relative petition for them. You do not need to wait for the US citizen husband, in this case, to file a petition for the spouse to become a permanent resident. You don't need the spouse to become a permanent resident so that the permanent resident parent can then file a petition for the kids. You can now treat the US citizen spouse as the parent of the children and file a petition directly. It would take about the same as petitioning for a biological child, at least in the context of consular processing. When we're talking about the child who's in the US, assuming they entered legally with a visa or were paroled and meet all the other requirements for adjustment of status, it's pretty similar. So a US citizen step-parent can petition for the child, and the child can apply for adjustment of status through that US citizen parent, as long as the US citizen married the child's biological parent before the child reached age 18. So interestingly, this step-parent, step-child relationship needs to be created before the child reaches age 18, but the relationship will continue until the child is 21. So even if the parents married when the child is 17, the US citizen step-parent in this case can still petition for the child when the child is 19 years old, all the way up until 21. The definition of a child is anyone who's under age 21, but that step-parent, step-child relationship must have been created before the child's 18th birthday. Another thing I want to mention here is in the first example I gave, where the US citizen married an immigrant spouse and the immigrant spouse was in the US, if that immigrant spouse is in the US without status or illegally present, or even in a situation where there's no way to fix that immigration status, that step-parent, step-child relationship between the US citizen and the children who are outside of the US still exists. And they have no immigration violations since they've never been in the US. So that US citizen step-parent can still petition for those children. And the weird outcome here is that those children becoming permanent residents and migrating to the US depends on that good faith marriage between the step parent, the US citizen parent, and the biological parent. But that biological parent's immigration status might never even be fixable. So they'll be out of status, but since it's a good faith marriage, the children are able to legally move to the US and become permanent residents and be on a pathway to citizenship. So the immigration law leads to these weird and inconsistent and what some people would say unfair outcomes. And it's just something worth mentioning in this video. All right, guys, that brings us to the end of today's video. If you have any questions or you are trying to file a family petition for your spouse or parent or child, then please reach out to us. We would be happy to assist you with any sort of family-based immigration case like that. We also focus on naturalization cases and deportation defense. So if you need any assistance, I'm your guy. You can book a consultation by just clicking the link in the video description below. If you're new to my channel and you just want to learn more about immigration law or stay up to date on recent changes under the Trump administration, be sure to subscribe to my channel. I've been putting out 5 videos a week, and I'll see you guys next time for another video.